Let's go over and get another perspective on the same matter. Makba?
So your name is Silas Ono.
Yes.
Well, thank you, Chamberlain. I have with me Mr. Silas Ono, who is a legal practitioner, and he's going to be giving us another perspective to this matter. How do you see the views of Mr. Adekunle Ojo?
Well, he's entitled to his opinion, but you can see that he was struggling to justify what he was saying. Because if you tell the truth, you won't have to struggle to say it. But if you're trying to go
think
around the truth,
is it about the
struggle.
truth of the fact that this is a very delicate matter and you're dealing with both legal, what is legally and what is out there in the court of public opinion?
As a lawyer, you tell the truth when you look at the evidence presented in court and the person being accused of committing an offense, and whether this evidence are enough to justify the crime he's being accused of. If it is not, you should say so. That is what you're expected to do as a lawyer. You shouldn't try to say, oh, someone came and said he transferred money, and because he transferred money, so he's guilty as charged. No. You see, in criminal law, the defense is not expected to come and prove his innocence. He can come there and just sit down and watch the prosecution. When he believes that they've not done anything to justify their charge against him, he just tells the court, my lord, they've not shown anything worthy of your attention to convict me of any offense. And that was what happened. Now, there are 4 witnesses, 48 exhibit, 18 count charge. None of these charges was justifiable in law. Mind you, apart from saying he received salaries from Kwara State government after having served as governor, he's still receiving the salary of that governor that he was. All the other charges were basically tied to companies. Now, they just suspected the man and charged him. That is why they just said this thing borders on intelligence, not on investigation. You just felt that the man had done something. And because the man has run for the office of the Senate President against some political interests and emerged, so their political relevance was reduced, or they felt it was declined by his emergence. So they needed to teach him a lesson or two.
I mean, you definitely we still have to prove that as well.
Yeah.
But what you seem to be saying is that the charges that were brought by the prosecution could not be linked to the defendant.
None could be linked. You see, most of the properties, or even all of the properties they said this man had, belonged to companies. Now, Mr. Ojo knows that companies are legal personalities. They can sue and be sued, and they can own property in their names. And this man actually declared his stake in these companies. That was all he was expected to do. To say, I have shares in A, B, C, D companies. That doesn't make him the owner of the properties. At best, he's a member of the company. Now, if you want to nail such a person and say the property belongs to him, do your job, do due diligence. There's alter ego, there's instrumentalities that you need to unveil in order to tie those properties to him. But because you just suspected him, you jump to court and say, he's a shareholder in this company, therefore he must be the owner of the property. That is wrong.
Should we say then, or can we say then, that no due diligence was done on the part of the prosecution?
Nothing was done. To show you that nothing was done, the lead of the prosecution team didn't even show up in court the day the judgment was delivered. He knew that they didn't do anything. If he knew they would win that case, he would be there to address the media. But he knew they didn't do anything, so he avoided the court. If he knew,
would he have been, if he knew that there was going to be nothing to the case, would he have pursued this case for 2 years?
The case was just a big drama. The tribunal, or the chairman and member of that tribunal, if they were not people interested in doing justice, had every reason to want to punish Saraki. Because during the trial, you see some of the lawyers representing him, even by some utterances, try to insult this panel. They said they were not judges. In fact, this place is not a court. You have no jurisdiction. And then these matters were going on appeal and returning. So more or less they harass this chairman and member of the tribunal. And we heard Saraki also during the trial say, hey, nobody took my statement. You're supposed to take my statement. That goes to doctrine of fair hearing. And the tribunal mentioned that. If there was a petition against this man, did you call him to take his statement? No, you just took the petition and went to court. He's supposed to write so that based on his statement, if he admits anything, it becomes part of your evidence. If he doesn't admit, you need to do some more work. You
say that the prosecution did not do due diligence.
They didn't do any diligence.
You also insinuate that, perhaps they were being used as political pawns in a game.
Mr. Samuel has been in CCB for 20 years. 20 years. Doing similar kind of duty, going to court. How can somebody in his standing come to court and say the evidence he's presenting was given to him by a team? Who in the team got that evidence? The person in the team that got that evidence should have been in the box. Because if it is not the statement of the person who heard, saw, or perceived, then it is hearsay. The person who saw, heard, or perceived must be in that team. Why didn't the prosecution bring the person? It tells you that the man is just trying to be evasive. This thing was just a big drama. And a lot of us fell for it because we felt, they must have gotten some evidence and they're going to nail this man. Because we have this common ill feeling against our leaders. We believe they are all bad people. So whenever one is caught with something like this, we want to pull him down, irrespective of who is fighting him. But we know that, yes, if this man didn't run for Senate President and won, nobody would take him to CCB.
Does that mean that he is clean, is squeaky clean?
That is a different thing entirely. But what they have brought before the court have all been knocked off. And the effect of the judgment, because it's not just a discharge, there's also an acquittal. This is the judgment, I have it here. Discharged and acquitted, they can never try him on those counts again.
What if they appeal?
Well, if they appeal, if they are lucky with what I've seen the prosecution did, I don't think any appeal will support them. I do not see it. I'm not a senior advocate, but at least I have the basics that I need to practice law. And looking through the evidence they presented, no court of appeal will overturn this judgment. No court of appeal. Because the whole thing was hinged on suspicion. If you suspect a person, that doesn't make him guilty.
You don't think that this is, because some people are also thinking that this is some political resolution, that perhaps there was a political, if you allege that all of this was politics in the first instance, then it is possible that behind the scenes there's been some amicable resolution, and as such, perhaps they have decided to drop or ensure that the case is watery.
No, I do not think so, because if you go through the process of the trial, the prosecution amended their charge about twice or three times. Because each time they come up, the defense team will puncture their case and they will go back and amend and come back again. Now, if there is a resolution, political settlement, what you get is withdrawal. They will withdraw the case. If you're saying there's a political settlement, it means the CCT is a political tool.
Well, you already said it.
The CCT is not a tool. The prosecution